Good morning. I'd like to welcome everybody to the webinar this morning. Virginia Ability and Richmond SHRM are pleased to have Steve Brown present on legal updates to the Americans with Disabilities Act as we celebrate the 30th anniversary of this important legislation. If you have any questions during the webinar, please submit them through the chat box and we will present them to Steve at the end of the webinar. Steve is a partner at the Richmond office of the law firm Eisler Dare. He's a distinguished trial attorney with 30 years of experience solving challenging labor and employment issues. He's also an inspiring adjunct professor at the University of Richmond and a devoted JMU alum. Most importantly, Steve takes complex legal requirements and breaks them down into practical action plans for his clients. And with that, I will turn the presentation over to Steve.
Well, thanks, Mark, and good morning, everyone. I'm glad you guys can join us this morning to walk through the Americans with Disabilities Act and its 30-year birthday. We're also going to handle a variety of issues this morning. My goal is to be done in about 45 minutes to give you plenty of time for questions. So we're going to ask that you provide your questions. We'll hit them at the end and hopefully be able to answer everything that you have in front of you. If not, I'll get back to you. So sometimes I don't know all the answers, contrary to what my wife will tell you. All right, so our agenda for this morning is a packed one. Give me just a second to get the PowerPoint moving. So we're going to hit the ADA yesterday and today, and then we're going to spend some time on COVID-19 and the ADA, talk about a couple cases, and then hit the FFCRA, which is the Family's First Coronavirus Act. So let's talk about yesterday and today with the ADA. So the ADA is 30 years old. I've been practicing for 30 years. So before I went into practice, I was an HR manager. Before I was in HR, I was a supervisor. So I've dealt with these issues from a multitude of levels, just like you are dealing with them. And now I'm on the legal end of those. But let's talk about what the basics are with the ADA. The ADA focuses predominantly on two things: a qualified individual and someone with a disability. This is normally what we litigate more than anything, is whether someone is a qualified individual with a disability. We don't litigate so much the disabling issues anymore since 2008. I'll explain to you why when we get to that. But at this point, we're going to look at a qualified individual as someone who can perform the essential functions of the job with or without a reasonable accommodation. And then somebody is disabled under the ADA if they have a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. The ADA is the only law we have on the employment side that deals with someone who could be regarded as disabled when they're not actually disabled. So it's an odd law in that sense, but it's a very real issue for folks that are litigating that, because employers do have a tendency at times to regard people as disabled when they're not. And if you're going to do that as an employer, you're going to be covered by the ADA, and that employee is going to have all rights as if that employee had a physical or mental disability. So when you're evaluating what it means for someone to be qualified under the ADA, we look at two things. One, we look at whether that person can actually do the primary functions of the job. Do they have the knowledge, skills, ability, and education to do it? And then we also look at the issues of whether they can perform the essential functions of that job. And employers don't always do a great job analyzing what essential functions are. Many job descriptions that I see are loaded and are multiple pages, but not everything that an employee does for you is an essential job function. They usually can boil down to probably between 5 and 8 really essential job functions in any applicable job. So from 1990, when this was first passed, until 2008, employers really did not have to worry much about the ADA. And you may be thinking, well, what do you mean by that? Well, employers won 74% of these cases when they became lawsuits. Employers would win them based on whether somebody was disabled or not. And we would challenge whether somebody suffered from a disability, and courts would almost 3/4 of the time grant our motions and throw these cases out. So for example, if you had somebody that had high blood pressure. What we used to argue was if you took your high blood pressure medication, you didn't have a disability. Now, you may think that's really silly. Why in the world would that court ever adopt that? Well, the courts then said, we agree. If you're taking mitigating measures, you don't have a disabling condition. Not necessarily true. You still have the condition. It's just the mitigating measure actually helps ameliorate that issue for you. On the other side, when we were dealing with whether somebody was qualified with a disability, employers won almost 50% of those cases. And what we would argue is that somebody with a disability that could not perform one of the job functions was not qualified and was not a qualified individual with a disability. And the courts used to agree almost 50% of the time. So disabled employees had a very difficult time prior to 2008 winning these cases. And in fact, employers did not really have to do much in terms of the accommodation side of things. Now, these are only lawsuits. There's tons of employers that do the right thing. So don't get me wrong when I say employers didn't have to do much. A number of employers did exactly what they should do under the Act. It's just if you got sued, here's how the case is set up. Then the Americans with Disabilities Act Amendments Act came in. So the ADAA came in 2008, and it reversed a number of Supreme Court decisions that came out over that however long period of time, that was 18-year period of time. The Congress decided that they wanted to really get the ADA back to what it was designed to do, which is level the playing field for folks that are disabled. The ADA was never meant to do something special for disabled folks. It was meant to honestly just level the playing field so that they could compete with everyone else. Makes complete sense. And so they went back and started to carve back in that law a number of decisions, which I think many of these are correct. I mean, it's exactly what should have happened, because I think the courts went way the other way. And let's see what happened from 2009 till now. So during the last 11 years, employers have won 46% of the cases when you've had lawsuits come up about whether someone is disabled or not. That's a huge reduction. Remember, it was almost 75% in the slide I just showed you a few minutes ago. It's gone down by 25 points. Most employers do not spend time challenging whether someone is disabled. Under the 2008 amendments, it's much broader now to encompass whether someone is disabled. If you have high blood pressure, if you take my example, and you take high blood pressure medicine, the law says you're still suffering from high blood pressure. It just means you found a way to live with it. Doesn't mean that you don't have a disabling condition. So it took away that argument from the employers. Employers are, fighting a number of these different things in terms of defenses, but at the end of the day, it's a much more fair law. I like the way the 2008 amendment set up for employers and employees. Again, during this 11-year span, employers won about 70% of the cases when you're challenging whether someone is qualified, or are they a qualified individual with a disability. This is a 21% increase. So what the courts have done is they've shifted their analysis away from whether someone is disabled. The focus now is almost solely on whether someone is qualified under the ADA for the job. And so what we argue as employers in these cases is that just because you have a disabling condition doesn't mean that you can forego doing the essential functions of your job. You still have to do them. And the courts support that. In fact, the 2008 amendments support that. The law has always been that you have to perform your essential functions, but this is where most of the litigation is ending up, is on whether someone's qualified or not. When we provide reasonable accommodations, and if you don't remember anything else from my presentation today, remember this: please communicate with your employees. If you will just simply, as an employer, communicate with folks, engage in the interactive process, which we'll talk about in a minute, and don't necessarily always refuse to do things, you can work out many of these issues in terms of reasonable accommodation. Most folks that have a disabling accommodation aren't looking for a free pass. They are looking for you simply to give them an ability to do the essential functions of the job. So if someone needs a bigger monitor because they're sight impaired, think about providing it. If someone needs, a different desk, right now I am standing at my stand-up desk. I've had the stand-up desk before they were popular. My dad made it for me 28 years ago. I've got a back issue, and so for years I don't sit. Now I'm finding in the literature you're not supposed to sit, but that's great. You've got a number of employees now that have back issues that need stand-up desks. They're not expensive to put in. The Veridesk, there's a variety of desks you can put in for folks, but I see a lot of employers just refuse to even engage in the discussion. Don't refuse. Talk to folks and try to work through it. There's certain things you can't work through, but there's a lot you can. You don't have to, as an employer, provide the accommodation that would fundamentally alter the job. So if somebody comes to you as an employer and says, look, your schedule is, 8 until 5. I take a number of medications for a mental disability. If I could work a shift from 9 until 6, would that work? If that can work for you, think about doing that for folks. If it doesn't, and you have to have people there from 8 to 5, that's fine. But just be prepared to be able to prove that. You don't have to give the employee their requested accommodation. You just have to give them a reasonable one. My view on this is if you can make the employee's requested accommodation and it's not an undue hardship, I would do that. So the interactive process. Well, this is when the employee comes to you and presents an issue that you need to look into. This is when you need to engage in the dialogue. You need to talk with the employee. Talk about what they need. Let them talk about what they need. Many times you will find that employees with disabilities will come to you and have a much lesser accommodation than you probably would have given them because they're not trying to be a burden. What they're trying to do is honestly level that playing field and do the job. So if you can make that accommodation that they want, do so. It's not an undue hardship. If the accommodation is not obvious, ask the employee if you're fine contacting the medical provider. You can do that under the ADA and should seek some medical advice. So what are some common reasonable accommodations? Job restructuring can be one, part-time or modified schedules, reassignment, changing the existing facilities to make them usable. You can see the list. The one thing I want you to focus on, if you don't remember anything else other than communicate, is think about whether attendance is still an essential function of your job after COVID-19. I'm doing this with a lot of my clients now. We're having a lot of discussions about whether attendance really is an essential function of the job. If it is, fine. We're going to talk about what it needs to look like if it's going to be, but you've got to be ready to prove it. The litigation we're going to see in the next few years is going to be on this issue. We're going to see tons of other litigation, but I can tell you on the attendance issue is the one that's going to be challenged the most relatively early. I look forward to having in the next few months when people are getting people back to work. People are going to challenge whether they really have to be at the workplace. So if you do require it, you need to then put in your policy as to why, because right now people are working remotely in a lot of locations. I think Google announced 2 days ago that they weren't coming back until July of 2021. So they've given their employees an entire year to think about how they're going to get back. Capital One's not coming back till the first of the year. Elephant Insurance here locally is not coming back. There's a variety of folks that are now phasing it in, but doing it slowly. So just know we're going to be dealing with attendance. During the pandemic, we're allowing people to telework, but if you don't believe that teleworking can work long term and you need to bring people back, make sure in your policy that you use some language that's similar to what I'm about to show you in the slide. You need to be able to support why they've got to come back. So I've given you some sample language here that you can use. You need to modify it for your workplace. But honestly, you need to prove why you need face-to-face conversations with folks. Why do they need to be physically in your office? What is the real advantage to having people there? Make it very clear that temporary teleworking is simply that. It's only going to be temporary, and that you're requiring that attendance be an essential function. And talk about exactly why. So if it's collaboration in the workplace that you need, I understand that. All those types of reasons should be there because you're going to have to prove that in front of a court at some point. And we're seeing it now with the public school discussion or the school discussion. You're seeing folks that are on the pro-student come back to school side of it say that you can't really learn well remotely. You're seeing the folks that don't want to go back now for safety reasons say we perfectly can do it remotely until we get a vaccine. We're going to see all kinds of fights over that, but we're seeing it in the workplace as well. So what's an undue hardship under the ADA? Well, the undue hardship is very difficult for an employer to prove. And that's on purpose because every employer would claim they had an undue hardship if they could actually make it easy, and it shouldn't be easy under the ADA. So the following factors you look at is to determine whether you have an undue hardship. How much is the accommodation going to cost? What's your overall financial resources? It's going to be much different if you're a multi-billion-dollar employer versus if you're a small employer. It's very difficult for Walmart to argue that it's a undue hardship for them to pay for a certain accommodation for an employee than it is for somebody who's much smaller. So they look at those types of resource issues. And what's the effect of that accommodation on your operation and your expenses? If you're going to rely on an undue hardship as an employer as one of your defenses, you've got to prove those 4 requirements above, and it's extremely difficult to do that. So what kind of disability-related inquiries can you make, and what should you make? Now, during a pandemic, it's different. I'm going to give you the general rule, then we'll talk about what you can do in a pandemic. The general rule under the ADA is that if you're making a disability-related inquiry, you can ask someone, a variety of different questions, but you've got to be extremely careful when you're delving into disability-related issues. So you can ask about whether someone's suffering from the flu, if somebody has a cold, but you've got to be extremely careful and not get into issues such as I've given you here. You can't ask people about whether they have a compromised immune system, or if they're suffering from cancer. You can't get into those inquiries unless the person wants an accommodation. The person comes to you and says, "Look, I'm suffering from the effects of cancer. I'm going through chemotherapy. I need a job restructuring, or I need to change my time." That's different. But if you see someone who's just not looking well, you can't go to them and say, "Gee, I think you have cancer." You can't do that. That's an improper inquiry, and you shouldn't do that. A medical exam. Under the ADA, we normally cannot do medical exams of folks, and this is where you're seeking information about their physical or mental health. You can do it at some points during the pandemic, which we'll talk about, but normally you can't do a medical exam unless it's job-related when we don't have a pandemic. We're not going to spend much time on that at all, but you got to be extremely careful on a medical exam when you're not in a pandemic. During employment, you can make disability-related inquiries. You can have medical exams if they're job-related and consistent with your business necessity, but you're going to have to prove that. So you've got to be extremely careful, during non-pandemic times as to when you do a type of a medical exam. The direct threat issue. If somebody is a direct threat to your workplace or to themselves, you look at 4 different factors. One is the duration of that risk. The other is the nature and severity of it, the likelihood of potential harm, and the imminence of that harm. Now, during COVID-19, folks that are positive for COVID-19 are direct threats to your workplace. During COVID-19, you can do medical exams in terms of limited medical exams, but you can ask people about their health related to COVID-19. You can take temperatures of folks. There's a variety of things the EEOC is allowing you to do now that are not considered medical inquiries during a pandemic, and it's to protect the health and safety of the workplace. And those are all legitimate concerns, and that's exactly why we have the exception during a pandemic. The EEOC has given the guidance regarding what a direct threat is. They've indicated that COVID-19 is a direct threat in the workplace. There's guidance on their website about it as well. If you want to see it, I can send it to you, or you can find it on your own. The website is very easy to navigate. So here's a couple questions we can throw out there, a little FAQs. May an employer send an employee home if the employee displays influenza-like symptoms during a pandemic? The answer is yes. You're not going to make a disability-related inquiry because that's not what that's determined. But based on the CDC's guidance on COVID-19, you can send folks home that have COVID-19 symptoms. You should actually have a COVID-19 pandemic policy. Most employers should be implementing those. If you're not, you should. The law that just went into effect last week on the 27th, I believe, was the new temporary standards from the Department of Labor and Industry here on workplace safety. They also deal with some of these issues. You should have a policy that folds in those requirements as well as the requirements that we have under OSHA and under the CDC. How much information may an employer request from an employee who reports feeling ill or calls in sick? Well, the employer can ask about symptoms that are COVID-19 related: fever and chills, cough, sore throat. There's a lot of more symptoms than that. I'm not going to cover them all. Fever is the big one. If you have a fever that's more than 100.4, we don't want those folks in the workplace. We don't want them in the workplace when there's not COVID-19. But remember, people used to come to work sick. They're not doing that much anymore. But you can ask about these symptoms that relate to COVID. Next question, may an employer take an employee's temperature to determine if they have a fever? Generally, the answer is no, but in a pandemic, you can. Whether you require people at home to take their own temperature before they come to work, I'm a big fan of doing that. I do that every day before I come to work. I'm a big fan of health acknowledgement forms. I've drafted a bunch. I love for employers to use them. You're entitled to have people tell you what their health is during a pandemic. But if you want to take the temperature gun and when they come to work and shoot those temperatures, you can. But you then, when you keep record of it, you got to keep it separate, make sure that the HR department is keeping that. But you can measure their body temperature. Next question, upon an employee's return from travel during a pandemic, may the employer ask about exposure to pandemic influenza during the trip? The answer is yes. You don't have to wait for folks to develop symptoms. I'll give you a good example. My paralegal is going to take her daughter back to school in Florida. She goes to the University of Florida. She's going to quarantine for 2 weeks when she comes back because she's going to a known hotspot, and to protect the rest of the office, she's not going to come in for 14 days. Now, she's going to get a test after 5 days. If she's symptom-free on day 10, she's going to call me. We're going to figure out, does it make sense for her to come in? The answer is probably going to be yes, because we socially distance here anyway. As I joke with other folks that I speak to, is that my staff has been socially distancing from me for almost 30 years. Nobody comes near me. So it's nice in our office that we have the 6 feet barrier no matter what. My paralegal can absolutely work within that. But if she's not comfortable and I'm not comfortable, she'll stay out the whole 14 days. During a pandemic, may an employer require its employees to follow infection control practices or wear protective equipment while at work? The answer is yes. So every day coming in, the requirement I have in my office is that we, from the garage into the building here and into our office, you got to wear a face covering. So I've got my face covering here. It's my JMU face covering. For those that are JMU fans, I'll wear that every day. But I've got multiple face coverings so that I don't run out of them. But anytime I leave this office space, I'm wearing my face covering. If I'm going to the restroom or I'm going to the cafeteria or the parking garage, I'm going to wear my face covering. Inside of our office here, you don't have to do it as long as you practice social distancing. So you can make people do that. And absolutely you should. At this point, we've got a spike in these numbers. We really got to get these numbers down. This is not a political issue. Wear your face covering, socially distance yourself. May an employer screen applicants for symptoms of COVID-19? Yes. So once you've made a conditional offer of employment to folks, you absolutely can. You can screen your current people for symptoms of COVID-19. May an employer take an applicant's temperature? You can. If you got an applicant that's coming in and you want to interview them and you don't want anybody here with a fever, you can take their temperature, and you should. So that's the traipsing through kind of the litigation, or not the litigation side, but at least the formal side of the ADA. Let me give you a couple cases here that I think will bring home the point even further. And cases are usually problematic for employers. Some set some great law for employers. Many times when I read these employment cases, I cringe at the number of times that I know an employer could have settled this case or resolved the case without it being reported. This is one of them. So this case is called Bell versus O'Reilly Auto Enterprises. It's out of the Maine federal court in 2018. And the issue is whether the manager of this auto parts store, who has ADHD, Tourette syndrome, and major depression, is a qualified individual with a disability and not the victim of discrimination or retaliation. The court found that he was a victim of discrimination and retaliation, and that a trial was mandated. What happens in a lot of these cases is we try to get these cases thrown out before they go to trial, and it's called summary judgment. So you go through your process, you get sued, you take depositions, you get testimony in the case, and then you tell the court, look, you don't need to have a jury decide this because as a matter of law, we win. And most employers have a good success rate in getting these cases kicked out before trial. But this case was not one of those. The court in Maine said, no, there's too many issues here and we're going to try them. And you'll see when we go through the fact pattern, how the employer created issues that they could have really resolved. So Mr. Bell's doctor proposed that he have a schedule change to only work 45-hour work week. Now, what O'Reilly Auto Enterprises has, and a lot of employers do in retail, is if you're managing a facility like an auto parts store, you don't have any hourly requirements. Basically, they can work you anytime you want because you're an exempt employee under the Fair Labor Standards Act, but also they don't want to put hour requirements in your job description because you really have to be there to get the job done. And so in his job description, it didn't have an hour requirement. But what his doctor said is, look, he's burned out. He's got a number of issues. We believe a 45-hour work week would be fine. He could work more if need be, but during this time, we'd ask that you limit it to 45 hours or at least put that in his job description. O'Reilly didn't like it. And their whole deal was, no, store manager's in charge of everything: profitability, appearance of the store, general operation of the store. We're not going to put an hour requirement in there. You got to do what's necessary. And when you applied for the job in 2014 and you took the job, you told us you could work any hours. And so now Mr. Bell is telling O'Reilly, well, I've got a disability. O'Reilly saying, we don't think you do. And in June of 2015, Mr. Bell had a meltdown where he claims he had been working extreme hours for the past 2-week period. He went to the doctor. They did a fitness for duty piece on him and stated he really shouldn't work more than 45 hours during that 5-day work week. And instead of contacting or really having a discussion with Mr. Bell, the O'Reilly's management got upset with the requirement. And they said, well, since you can't work 45 hours a week, you're not a qualified individual with a disability. And if you can't do unlimited hours, you can't do the job. And instead of having a discussion about his accommodation request with the nurse practitioner, they just refused to do anything. And the nurse practitioner would have told them he can work more than 45 hours. His scheduled time should be no more than 45. But if he's needed, he can do it. But they never had that conversation. And so what they decided to do was tell Mr. Bell, well, you can't do the job. And so we're going to allow you to do another job. We will transfer you to an assistant job, assistant store manager job somewhere else, or we'll pay you less money in the job you're in. But that's what our accommodation is. And Mr. Bell sued. And so then the court looked at a couple of things. And that's why I wanted to show you the case, because I think you'll see how the law that we just talked about applies in real life. The court looked at the failure to accommodate claim. Mr. Bell said, look, you should have just accommodated my request. I only asked for a 45-hour schedule. I said I could work any hours you needed, and I didn't ask for my job to change at all. And so the court said, you first have to show you're disabled, and then you have to show that you could perform the essential functions of your job with or without an accommodation. And what the court concluded was he was disabled, and the judge then looked at whether or not these extended, unpredictable hours were an essential function of the job. And the court said, I think that's for a trial and for a jury to look at. And what the judge was really upset with is that they did not engage in the interactive process. They didn't take the time to sit with Mr. Bell and talk to him about how they could work through this. And honestly, if you would have sat with Mr. Bell, now that you know something about this case, and we would have sat in a room with him and said, look, I now understand 45 is what you want to be scheduled for, but if we need you to work 55, you can do it. We're fine. And we'll work through this with you. And the evidence is that Mr. Bell rarely worked more than 46 hours a week, no matter what. So it was, in my view, a bit unreasonable for the employer not to even have the discussion. And the same was true for the court. The court found that to be problematic. They found that having to work different hours makes sense. But at the end of the day, if he rarely worked more than 46 in a week, why didn't you sit down and talk to him? And the court said, let's have a jury figure that out. He offered a reasonable accommodation. And he basically said, I'll work what hours you need. I just want to make sure on my fitness for duty form that you only schedule me for 45. And the court said, that's enough for a jury to have to hear this, because O'Reilly's telling one story, Mr. Bell's telling another. The court then looked at the interactive process and was upset with the way it happened. Employers are required to engage in good faith and meaningful dialogue with their employees to talk about an accommodation. Many employers don't do this. And what I would love to see a lot of employers get back to is putting the human back into human resources. sitting down with folks and having these discussions, you can work out 99% of these. There are some you can't. There are some people that will be unreasonable, but by and large, the workforce out there is not unreasonable. They're not looking to take advantage of the employer. They're really trying to figure out how can they do the job. Now, if they honestly can't do the job, that's fine. You as the employer can make that decision. That's not going to be a disability-related discrimination claim, but most folks are really just trying to work through it. So the court looked at the interactive piece of this and said, look, they didn't even have anybody from Human Resources talk to him. They had their field managers, their people out in the field do the discussion. So nobody that was even trained in disability discrimination even spent the time discussing anything with him. And so the court was bothered by that fact and said we need to have a trial on that issue. The same on discrimination. The court thought there was enough evidence for this case to go to trial on discrimination, and said the jury's going to have to sort that out based on the facts that you've heard. The court looked at a number of things on how to develop a discrimination case. And in other words, if you're going to prove a case, you have to show, first of all, you're disabled under the ADA. You then have to show you're qualified to perform the essential functions with or without an accommodation. And then you have to show that you were subjected to an adverse employment action due in whole or in part because of the disability. And Mr. Bell was able to show that. And the court said there's enough here for the jury to decide whether or not you, O'Reilly, as the employer, were lying about the reasons that you moved him to a different job. Because O'Reilly said, look, we offered him a job as an assistant and a store manager that was lower in pay. And Mr. Bell said, well, I think they're lying about that, first of all. And I think the real reason they offered me less money was to discriminate against me because of my disability. And the court said, let's let a jury decide it. On the retaliation claim, and these are some of the biggest claims I see. Discrimination claims are not as prevalent as people think, but retaliation claims are. And the reason we see more retaliation claims than we do discrimination is you never have to prove that you were discriminated to bring a retaliation claim. You only have to show that you engaged in conduct that's protected by the law. So if you complain about disability discrimination, that's engaging in conduct that's protected. If you can show something happened to you in the employment relationship, whether you were fired or demoted, that's going to get you to that level. And then you have to put a causal connection between the two. You've got to prove that your protected activity you engaged in caused what happened to you on the adverse employment side. Not very difficult to prove retaliation. It's much more difficult to prove discrimination on the ADA, much harder to prove sexual harassment if we're involved in a sexual harassment case. Many times almost impossible to prove, but you can prove retaliation relatively easy. And so what he was able to argue to the court, and the court said again they needed a trial on, is he said, look, I engaged in protected activity by asking for an accommodation based on my disabilities. And what happened when I actually asked for an accommodation? You demoted me. You told me that you were going to make me an assistant store manager and pay me less money. That's an adverse employment action. And so what the court said is, I think a jury could find that you were the victim of retaliation, so the court denied summary judgment. The next case I want to go through with you is the Mack case. This was here in the Eastern District of Virginia. This was up in Alexandria in 2018. And the issue here is whether summary judgment was appropriate for a former employee who claimed she was a victim of disability discrimination and retaliation. In this case, the court threw out Ms. Mack's case. Now, Ms. Mack had diabetes, she had an anxiety disorder and hearing loss. She had sued a number of her prior employers and had a pattern of suing them. She would accept their employment. She would then immediately request a number of accommodations. When they were granted, she would request more. And when those requests were denied, she'd stop coming to work and she would get herself fired or she'd quit and then she'd sue. She had sued Lockheed Martin before this case. She'd sued Georgetown University. And so CGI had hired her to be a project manager, not knowing about her past, hired her in to be a project manager. She was given training, and her job was to provide training for new employees for other government contractors at their host site. So she had to go to these places and provide the training. Shortly after she started employment, she wanted them to pay for noise canceling headphones and give her a refrigerator for her insulin. The employer said, fine, we'll do both. 2 months after she was hired, she had a doctor sign a form that said she had anxiety and she should limit interacting with others, and she had trouble concentrating. Now remember, her job was to go to different governmental contracting sites, interact with people, and do training. And so 2 months into the job, she's getting a doctor to say she can't do her essential job function. And so what she did is she went to CGI and she said, look, I only want to go to one site. I really don't want to have to do much. If you have something, give it to me in writing. And they did. So what they did is they limited her travel and the job that she was supposed to do. They gave her job tasks in writing as opposed to her developing them based on her job description. Once she got that, she then said, well, she liked one site over another and she wanted a private office at a site. This is when the employer said, no, nobody has a private office. We're not going to give you one. She was written up for insubordination shortly after that. She left work after the warning, claiming she had a headache and her ears were ringing. She then said she needed to be out of work for a week because they had a meeting with her about her performance and she was anxious about it. But in August of 2016, her doctor came up with more medical issues, seeking more accommodations. She then wanted to telework. The employer said, no, we hired you to be in person, training people at different job sites, so we can't have you telework. She wanted all of her non-essential job functions moved and taken away from her. The employer said no. She continued with this, what I will call nonsensical requests, because these were. She wasn't trying to do her job. She was honestly trying to get fired, and she did. She got herself fired. She got a new job 4 days after she was fired. And so the court looked at a couple things. They looked at the analysis was she an individual with a disability? Did the employer have notice that she had a disability? Could she perform the essential functions of the job with or without an accommodation? And did they refuse to make those accommodations? Well, she failed on 2 of these requirements out of 4. She could not do the essential functions of the job, and the court found that CGI made every reasonable effort to accommodate her. They said the only thing CGI didn't do for her is allow her to telework and remove her self-described non-essential job duties. When you read the case, you'll see that she wanted most of her primary job duties taken. She called them non-essential. The employer believed them to be primary and essential. The court then determined, like they have in many cases in Virginia, that attendance is an essential function of the job. And the court said, look, it's understood that many jobs require teamwork. We understand how that works. But at the end of the day, you need to be on site to do the training you were supposed to be. You had performance issues, and you were not even there for 100 out of the 260 work days that you were supposedly supposed to be working. So she lost that case. And you can see the difference between the Bell case and the Mack case. Completely different fact scenarios. One case where somebody's really trying to perform the job, the other one where somebody's really looking to get out of most of the job requirements. And the courts aren't going to put up with that when you do that. What are we going to see from future litigation? Well, one I talked about already is attendance being an essential function. We're going to see that as future litigation. Reasonable accommodations in the workplace, scheduling issues. Are you going to let people work different schedules to avoid having to be around other folks? Failure to accommodate folks that are afraid. We're going to have a number of folks, and we do now, that are afraid to come back to the workplace. And so we're going to be dealing with those issues as well. Is that legitimate enough for you not to come back? So those are going to be some of the future litigation trends that we'll see. Let's spend a little bit of time on the Families First Coronavirus Response Act, and then I want to get to your questions. So I'm sure you probably have a bunch. So on March 18th, 2020, Congress passed the Families First Coronavirus Response Act, the FFCRA. This was passed as part of the global pandemic dealing with COVID-19. It was effective April 1st. It expires December 31st unless it's going to be expanded. We'll find out today, I guess, or tomorrow if Congress is going to expand the unemployment benefits that are out there as part of the CARES Act, but that's different from the FFCRA, so I won't get distracted on that. There's 2 different categories that were created under the FFCRA. One was up to 80 hours of emergency paid sick leave. The other is up to 10 weeks of emergency family medical leave. And it's very restricted. It is not at all what Congress anticipated when they passed it, because the regulations are much more draconian, much more employer friendly. And I'll be very frank with you, I'm surprised at the regulations and how they came out, because I did not expect them to be as employer friendly as they are. And we may see some modifications of that coming up. The Department of Labor is responsible for enforcing it, and they are enforcing it. They have a number of folks that they've hired to enforce it. So what do you get in terms of leave? So it gives you, if you've got 500 or less employees as an employer, you're covered. If you're over 500, you're not. But it gives you paid sick leave if the employee is subject to a federal, state, or local quarantine or isolation order due to COVID-19, if the employee's been advised by a healthcare provider to self-quarantine. That does not mean the employee believes they should self-quarantine. The healthcare provider has to do it. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So you can't just be experiencing these symptoms without going to get a medical diagnosis. You're caring for someone who is subject to the quarantine or isolation order. The employee is caring for a son or daughter whose school or place of care has been closed due to COVID, or that their child care provider is unavailable, and then there's a catch-all that we don't even know how the catch-all works, to be very frank with you, because nobody has used it. So the amount of sick leave you get up to 80 hours of paid sick leave. So it's not a lot, and you can supplement it with your PTO if you want to, but it's really 14 days or 80 hours that you can use. The big issue that I see dealing with this is going to be with the school children, which I'll get to in a minute. Part-time employees, they're covered as well. There's a number formula on how you can figure out how the part-timers are covered. And I've given you some of that in here so that you can see it. I'm not going to spend a lot of time on the math. That's why I went to law school, so I didn't have to do math. Leave entitlement. Under your emergency family medical leave, you are eligible to take 12 weeks of leave to care for a minor child whose school or daycare has been closed. The key here is if it's really a minor child that needs your help. Now, if it's 13 years or older, the regulations have said that child can usually operate on his or her own. Now, we all know I've had 13-year-old children. They're not that way anymore. They're grown adults. But I can tell you back when they were 13, I'm not so sure, or 14 or however old they were, that they could function on their own. But the law really is set up for younger children. If you've got older children, it's going to be difficult for you to claim you need to be home to watch them and take leave. So just know it's a little bit more restrictive. It also requires you to find other people that can do that for you. So it's not as clear cut for folks to take emergency paid family medical leave. You get 10 days of your paid sick leave that you can tack on to the 10 weeks. So basically, if you're taking emergency family medical leave, you get a total of 12 weeks total. It's not a lot of money, but it is helpful. So it can definitely help you and supplement what you're doing work-wise. For employers, you should be working with these folks, if you can, around scheduling. In our firm, I've got 2 folks now that are working that have children that are school-aged. They end up doing a lot of at-home schooling and then trying to do their work in between. So we're, really trying to work with them to modify their workday if they need it to be modified. And it's something that all employers should be able to do, if you can do it. Some employers can't, but if you can be flexible, be flexible. You got to post the FFCRA poster in your place where you post other employment posters. You can copy it right off the DOL website and then just print it and put it up there. But it's got to be up there. It should have been up there in April. So let's look at a couple issues that we have that are common to all of these employers that have to satisfy this requirement. If you've got people that are teleworking, you should be sending it out to them by email. Doing a posting in a place where nobody's coming to is not effective. And so the Department of Labor said if nobody's at your workplace, you've got to send it to folks, or you got to put it on an external website, something where they log on and they see it. You've got to at least put the effort out there to get the notice there. All right, a couple FAQs. On July 20th, last week, they came out with some additional guidance. I'm giving you the link here if you want to pull it up, but basically deals with employers and how you can enact different policies to keep people that are vulnerable out of the workplace. You can do that, but you can't keep them out forever. So if you've got people that are vulnerable, you need to work with them and talk with them, but you can't have a policy that keeps them out of the workplace forever. There's also some additional guidance for the ADA, but nothing that we haven't covered. We've covered everything under the ADA that you would need. So I went 3 minutes over what I told you I would, so I apologize, but I'm available to answer questions.
Hi, Steve. Thank you. That was very informative, and also the details in the slide will be helpful. We will send those out, make them available on our website. This is Bob Lancaster with Virginia Ability. So I'm going to read off some questions that I've received. The first is, can you address the responsibility of ADA accommodation for employees to seek treatment for substance abuse?
So twofold. So to seek treatment, I'm trying to do it because I need a little bit more detail. If you're a current person seeking treatment is not covered by the ADA. So the ADA only covers former alcoholics, former drug abusers. It does not cover current users. The FMLA may cover it if you have 50 or more employees, but you are not covered if you are relapsing. You're not covered by the ADA. So if that's what they're getting at, I don't know if that's what the question was getting at, but that's the more generic answer.
Okay, thanks for that. What advice would be given to an employee who has a non-apparent and non-disclosed disability, yet in being asked to return to the office, feels he must disclose in order to explain why he feels uncomfortable returning? Will that be an interactive process that HR must be prepared to have?
Yes. So the way I understand the question is you're living with someone, or you're in close contact with someone who's a non-parent but does have some underlying health condition that may be a disability. Does that person have to disclose that to HR through the interactive process in terms of trying to determine, do they have to come back to the workplace, or can they do something different? The answer is yes. If you're relying on the underlying medical condition of someone as your reason why you can't come back to the workplace, you have to disclose what that is, and during the discussion really determine, how this is going to work. A number of folks have underlying health conditions before COVID. People seem to forget that. So people that are vulnerable have been vulnerable for a long time. And so just because COVID-19 is out there doesn't change the necessary vulnerability for those folks. They are more susceptible, obviously, to COVID-19, but they've been susceptible to a number of infections and viruses. And so whatever protocol you were taking before COVID-19, you might be able to take additional protocols now. The advice I've been giving folks that have vulnerable people at home, maybe you change at work. If you've got a clothing issue and you think it lives on the surfaces, I know the data is not as strong on that anymore about COVID on the surfaces, but I'm not going with anything yet. 4 months ago, we were told face coverings weren't important. So I'm thinking anything you can do to protect yourself from COVID, I'm thinking it probably still lives on surfaces. Maybe you remove your clothing at work and change into something else, or you remove your clothing in the garage. You do whatever you can to protect that person, but if you want an accommodation, you're going to have to disclose it.
Okay. And it sounds like that is similar, regardless of what category you may fall into, older workers, et cetera. On a personal note, I am interested in whether you envision cases, for example, I have a daughter with Down syndrome employed in assisted living. She's been furloughed since March, and we have yet to hear whether or not she'll return to work, or whether she'll be able to keep her job, even though she is willing to go back and has communicated to HR and to management. If the case turns out that she's terminated from her employment, do you see a potential case in that, or a recourse?
It's going to be harder for me to opine on things like that because I represent long-term care facilities and nursing facilities, and I don't want to say something that'll be used against me. So without knowing more of the facts, it's more fact intensive than that. It really depends on a variety of things. So for example, if they can't bring her back because of revenue issues, or they've determined that from a staffing standpoint, they're only going to have so many staff, and they're ending up letting people go. They're letting people go on the variety of ways, but they're going to use a reduction in force analysis, and let's say they use seniority, and she doesn't have as much seniority, or they use job performance. If they're doing it the right way, then they're going to be protected. If they're just willy-nilly firing people that have disabilities as opposed to folks that don't, that's a problem. So without knowing more, it's hard for me to opine on that. My hope is that they bring her back.
That's helpful, I think, even for participants and how to look at it for their own situations. And I do have one more question here. Can you do intermittent leave under the FFCRA if you have a school-aged child under 13?
You can if the employer agrees. So the only way intermittent leave works under the FFCRA is the employer has to agree to it. The employee doesn't have a right to it. And so if the employer wants to agree to that, sure, you can absolutely do it. And that's going to be up to the employee and the employer to work through it.
Okay, that is all the questions I have in the queue. I'll give it a few minutes to see if anybody else chimes in. I don't know if you have any other final words, Steve?
I don't, and I'm not usually without final words. I'm usually going over what I'm supposed to do. I don't usually have time at the end to talk about anything else. But so let me think if I can give you some additional analysis that will help folks that aren't necessarily on the ADA side, but maybe on some other issues. I will throw out to you some other problems I'm seeing in the workplace, which may be helpful for folks. One is on the management side. Managers, for some reason, not everybody, but I'm going to throw it into a very generic category, have decided that they don't have to manage because people telework. And so management of employees has really taken a dive in the last 4 or 5 months. Managers still have to manage their employees when they telework. You still have to record time for those folks. We're seeing a lot of wage and hour violations for employers that are not tracking their people's time. People work more at home. They will work longer hours at home. And so employers are required to make sure under the Fair Labor Standards Act that they're tracking all hours worked for all hourly employees. I'm finding I'm working more when I'm at home. I'm at the office today. I'm usually here 4 days a week, and then I work 1 day at home. Was doing that before COVID. But you find yourself getting up earlier, working more, and working later. Same is happening for your hourly folks. So make sure you're tracking your wage and hour issues for your folks. Make sure you're doing training by Zoom. If you're not in person, have tons of interaction with your folks, tons of communication. Do it by Zoom or GoToMeeting or whatever platform you use, but you need to be interactive with these folks. Don't leave them out there on an island and just kind of forget. So that's my plug on the other side of the law. There's many more things I could talk about with you, but that kind of folds in with the ADA and with the FFCRA.
Okay, well, I did get one more question in here, and then I've got a few things to close this out. The question is, can you give us 2 or 3 steps that employers need to do now to keep people with disabilities employed?
Well, so number one, I got to figure out my 3 steps. The first thing I would do to keep people with disabilities employed, over communicate. You should be doing that with folks that don't have disabilities, but you should definitely be doing it with your workforce. And to keep folks employed is to really talk with them about the essential functions of the job. There are certain parts of the job that you probably need to revamp in your job description. The other thing I find a lot of employers do is they write a good job description at the very beginning of the job, and then they never modify that job description as to what that person's actually doing. Look at your job descriptions and revamp them when they need to be revamped. Many of them have things in there that you don't need. A lot of people put lifting restrictions in job descriptions that don't have them or shouldn't have them. You shouldn't have that in there. You should make the job description true, exactly what the employee is doing. And that will help folks that are disabled and folks that are not to ensure that they stay employed. Number 2 is honestly and frankly, have evaluations more often than you do. Now, I know people are going to cringe that are on the call, and they're going to say, oh, my Lord, I hate doing these yearly. I really don't want to do them more than that. But you should be having good evaluation questions and documenting what the issues are, and have good evaluation discussions. People do a lot of good, and we don't spend enough time as employers talking about the good that people do. We spend a lot of time telling people what they do wrong. And I would love for employers to really focus on the good that people do, build on their strengths, don't necessarily always be poking at their weaknesses, and you will find that you'll have a happier workforce. You'll be able to keep people employed longer, and people are going to want to work for you. So that's May not have been 3, but those are my top 2.5.
Okay, well, thank you, Steve, so much, and Emily for interpreting the webinar today. This was extremely informative. And Steve, I guess with your permission, can we provide send the deck out to the participants and provide it on our website?
Absolutely, please do.
Okay, wonderful. And we did record this webinar. We plan to post it to the Virginia Ability website through our YouTube channel. And I want to thank, on behalf of Virginia Ability and SHRM hosting this event. And you can see on the last slide, it is approved by SHRM for one PDC. So I guess Steve and Emily will give you one last round of applause, and thank you so much for participating in the webinar today.
Thank you.